what's new? Ano bang bago sa land titling, no? And sige, let me walk you through at least very briefly on the background of the laws on land titling in the Philippines. Okay, next. Now, these are the governing laws on land titling and registration. Perhaps you may have encountered this in your studies. Number one is the Cadastral Act Cadastral Act, or Act number 2259, which was passed or enacted as early, as 1913. Baka lola natin, di pa buhay nito, no? And of course, the number two, which is the primary substantive law on land titling, is Public Land Act, or CA 141, no? Which was enacted during the Commonwealth era in 1936. And then, of course, the registration of property is contained in Article 708 to 711 of the Civil Code, no? Which was enacted in 1950. And the latest was the Property Registration Decree, or Presidential Decree number 1529, which was signed in 1978. Okay. Next slide, please. Now, as far as CA 141 is concerned, or otherwise known as the Public Land Act, it was enacted on November 7, 1936. No? And it governs the the classification and disposition of A&D lands of the public domain. No? And it prescribes certain rules and regulations on the homestead, no, homestead patents, sale, direct sale, or by way of a miscellaneous sales application, and of course the leasing of portions of A&D lands of the public domain. It also sets the terms and conditions that would enable persons to perfect their titles to public lands, no, in our country. Okay. Next slide, please. Now, this is a compilation of the then existing laws on lands of the public domain. And after a number of amendments, it has remained, to this day, the existing general substantive law governing the classification and disposition of lands of the public domain. No, of course, other than timberlands, mineral lands, and national parks. No, alam natin that under the Constitution, there are four major classifications of lands. No, the agfotimina. Tawag ko doon nag-aaral, nagre-review ako. Agfotimina. What's agfotimina? Agricultural, forest or timber, mineral lands, and national parks. No. Of all of these, only public agricultural lands can be capable of alienation and disposition. Okay? Malinaw yun, sa ating Article 12 of the 1987 Constitution. Okay, let's proceed. Now, the Public Land Act governs lands of the public domain. Lands of the public domain. Ito yung tinatawag natin sa Article 420 of the Civil Code, na property of public dominion, no? Parehas lang ito, no? Lands of the public domain and property of public dominion. Now, it explicitly enumerates the means by which public lands may be disposed of and alienated, no? Number one is homestead settlement. Number two, sale of agricultural land by way of public auction or bidding, no? Bidding. Number three, by lease of residential, commercial, and industrial land. And number four, by confirmation of imperfect or incomplete title, which can be done either through judicial legalization or administrative legalization, which is more commonly known as free patent, no? And town site reservations, and direct sale of residential lands. And of late, we have the residential free patent law. Nadagdag yun, yung residential free patent. Now, as to homestead, very briefly, I will discuss this. Homestead is available to any citizen of the Philippines of legal age, or he may not be of legal age, but he is the head of the family, who does not own more than 24 hectares of land in the Philippines, or has not had the benefit of any gratuitous allotment of more than 24 hectares of land since the occupation of the Philippines by the United States. sobrang tanda na ito, no? Kasi nandyan pa yung United States. Eh. And that citizen may enter into a homestead or apply for a homestead patent not exceeding 24 hectares. But of course, this should be read in conjunction with the constitutional limitation on the ownership of lands under the 1987 Constitution, which limits the ownership of lands of public domain to 12 hectares. No? So in 24, babasahin na natin siya na 12 hectares. Okay? Okay, next. Now, under the Public Land Act as amended, a homestead patent is one issued to a citizen of the Philippines, no? A Filipino citizen who is of legal age and who is not the owner of more than 12 hectares of land in the country. No? Wala siyang pag-aaring lupa o lupain na may sukat na mahigit sa 12 hektarya. To be qualified, the applicant must show that he is a resident continuously for at least 1 year in the town where the land is situated, and he must have cultivated at least 20% of the land subject of the application. No? 20%, 1/5. No? Okay. Now, as the sale of agricultural land by a sales patent, what are the requirements? No? Under Section 22 of the Public Land Act, he must be a citizen of the Philippines, no, of lawful age, and if he is not he's not of lawful age, as I said earlier, he must be the head of the family, no. The applicant may purchase, no, through bidding any tract of public agricultural land which is disposable under the Public Land Act, but that land should not exceed 12 hectares, no. Now, the purchase under that provision should be evidenced by, or will be evidenced by a sales patent. Ang tawag doon ay sales patent, which is will be registrable under PD 1529. And there is also the requirement of cultivation. No? Kailangan may cultivation kasi malalaking tracts of land to. No? We're not here talking of residential, purely residential land, but these are agricultural lands. Okay. Next slide, please. Now, we go now to the direct sale of residential lands under Republic Act number 730. This is what we call the miscellaneous sales application, or MSA. No? Under that law, which was enacted in 1952, it permits the sale, no, without bidding, without public bidding, through the miscellaneous sales application of A&D lands of the public domain of the Republic of the Philippines for residential. Residential lang ito, no? Residential purposes. Yung RA 730. Now, as to the miscellaneous sales application, this is an application to purchase the land, and after the approval of the application, the applicant will be issued a miscellaneous sales patent. No? Kanina sales patent. Ngayon ay miscellaneous sales patent. No? Okay, sige. Now, based on the provisions of RA 730, an applicant of miscellaneous sales patent by way of a miscellaneous sales application must be a Filipino citizen of legal age and must not own a home lot in the municipality where he resides. In other words, kailangan wala talaga siyang any real property in the municipality where he is a resident, and must have in good faith established his residence on a parcel of land of which is a public land, no, which is not needed for public service, no? Not needed for public service. Now, the applicant which meets these requirements may purchase at a private sale not more than 1,000 square meters. Maliit lang, no? Kasi residential ito eh. No? Maliit lang, 1,000 square meters of public land at a price to be fixed by the Department of Environment and Natural Resources. Okay? Now, let's go now to Property Registration Decree, or PD number 1529. One of the laws that we mentioned earlier as one of the governing laws in land titling. No? It is entitled Amending and Codifying the Laws Relative to Registration of Property and for Other Purposes. It was signed into law by former President Ferdinand Marcos on June 11, 1978. And the reason for the issuance and entry in the issuance of this, rather the issuance and entry in the registration books of the decree of registration can be found in the whereas clauses, no, of that decree. And it says the purpose is one, to update the Land Registration Act. Although alam natin na yung Land Registration Act was already superseded by the Property Registration Decree. Kung babasahin yung dalawang batas na yan, makikita ninyo na na-supersede na yung Act number 496, no? Which is the Land Registration Act by the Property Registration Decree. Why? Bakit ko nasabi? Kasi sinabi rito, codifying, di ba? Codifying, meaning it codified all existing laws on land registration prior to the enactment of PD 1529. So, hindi lang siya ina-update, kundi sinusupersede na niya, no? Number two, the number two purpose is to adopt safeguards to prevent anomalous titling. Yun yung purpose. Although alam natin, hanggang ngayon may anomalous titling pa rin. No? But that will be discussed in another webinar perhaps. No? I can discuss with you such topics as how to detect fake or spurious titles. And there are other topics that I can discuss in the future for the benefit of you, our students, no? And of course, to simplify, no? To simplify the registration proceedings. No? Kasi dati, despite the adoption of the torrent system of registration, we find that the system of registration in the Philippines is still very, very intricate and complex, no? Complicated pa rin, no? Okay, sige. Let us proceed. Now, basically, the Public Land Act is a substantive law, while PD 1529 is a procedural law. But let me invite you to Section 14 of PD 1529. Though it is a procedural law, it contains a substantive provision, no? Substantive provision, particularly in Section 14 of PD 1529. So, hindi ibig sabihin na procedural siya ay yung buong batas ay procedural, no? We can find that in Section 14, and we can later on we will discuss Section 14 vis-a-vis Section 48, Paragraph B of the Public Land Act. Okay. Next. Ayun, no? Kala ko nakatulog yung Anyway, as to confirmation of imperfect or incomplete titles, nabanggit natin kanina yan, confirmation of imperfect or incomplete titles. This can be done either by judicial legalization or by administrative legalization, which is free patent, no? Free patent. Now, the confirmation of imperfect or incomplete titles to A&D lands of the public domain may be done in two ways. Number one, judicial legalization, or what we commonly know as judicial confirmation of imperfect or incomplete titles, no, under the Public Land Act. And number two, the administrative legalization, or what we commonly know as free patent under Chapter 7 of the Public Land Act. So dalawa, no? Judicial legalization and administrative legalization. Okay. Next. Now, for judicial confirmation cases, the length of time required, the length of the required possession and occupation of alienable and disposable agricultural lands of the public domain under a bona fide claim of ownership was first changed, no? Yan lang kayo, babalikan lang natin, we backtrack to the history of the history of the evolution of the present law, no? Was first changed in 1957 by RA or Republic Act number 1942 from possession since July 12, 1894 to possession in such concept 30 years immediately preceding the filing of the application for confirmation of title. So in other words, ikaroon ng amendment, no? yung ating Public Land Act na possession must be reckoned from July 12, 1894 or earlier. No? In 1997, PD 1073 was enacted, no? Which changed the required period of possession from June 12, 1945 or earlier. No? In-adjust, no? From 1894, ginawang 1945. Okay? Next. Now, we go now to free patent applications. The required period of continuous occupation and cultivation of alienable disposable lands of the public domain was originally set under the Public Land Act to commence on July 4, 1926 or earlier. No? We're talking here of free patent. Administrative na ito kanina. Pinag-usapan natin judicial confirmation. Ngayon ay administrative, no? Or free patent. This was again changed in 1990 by the enactment of Republic Act number 6940, which changed the possession, no? The period, the reckoning period from July 4, 1926 to occupation and cultivation for 30 years, immediately preceding the filing of the application for confirmation of title. So at this juncture, hilong-hilo ka na, di ba? Hindi mo na malaman, confused ka na, hindi mo malaman ano ba talaga ang basis, no? It's a moving basis, no? Even lawyers will have a hard time figuring out what law to follow, no? But based on my presentation, it will become clear to you what law will prevail, no? Kasi kaya nalilito, meron tayong administrative, meron judicial, no? Okay, sige. At meron pa tayong prescription under the Civil Code, no? Iba pa yun, no? In 1990, Republic Act number 6940 was passed, which granted a period ending December 31, 2000 for the filing of application for free patent and judicial. Meaning, in-extend, no, up to 2000, year 2000, yung filing of applications for judicial confirmation and administrative legalization by way of a free patent application. And then, siguro walang nag-a-apply, nag-extend uli in 2002 by way of RA or Republic Act number 9176, which was enacted, extending further the period for application until December 31, 2020. That was just last year, di ba? 10 months ago. Oh. Okay, sige. Next slide, please. Now, here are my observations. Here are my observations based on my review and study of all of these laws. Number one, there are complex provisions on land titling and registration laws. Ang daming mga complicated and conflicting provisions in our existing land titling and registration laws. Number two, there are vague interpretations and implementation of this law. Malabo, no? May mga kalabuan, may mga hindi malinaw na pagpapatupad sa mga batas patungkol sa pagpapatitulo ng lupa. And number three, the requirements for confirmation of imperfect or incomplete titles are either outdated or very difficult to comply with. No? Ang hirap, no? Ang hirap ma-comply. This is the reason why, despite several extensions or a couple of extensions, the number of applications was very low. Otherwise, kung madali siyang ma-comply, sana hindi na nag-extension ng madami, di ba? Sana as early as 1970s, tapos na yan, di ba? But because mahirap nga, nag-extend na nag-extend. Now, there is also difficulty in meeting and proving in court sa judicial confirmation the period of the required possession that dates back from the period or to the period on or before June 12, 1945. Ang hirap no, di ba? Kasi ipoprove mo yung ownership or claim of ownership since June 25 or earlier. Di ba? Diba, marami sa atin, hindi nga natin, well, kahit na magulang natin, baka hindi inabutan yun, di ba? And of course, the problem of the surfacing of multiple claimants over the same parcel of land. Ang daming claimants hanggang ngayon, di ba? May mga lupa na ang dami nagka-claim. Especially if the land is untitled. Okay, number 4, the disparity between Section 14 and Section 14, Paragraph 1, and Section 14, Paragraph 2 of PD 1529 as amended. Now, Section 14, Paragraph 1, and what used to be Section 14, Paragraph 2 of PD 1529 were clearly different. Magkaiba siya. Kung babasahin natin. Section 14, Paragraph 1 covers A and D, alienable disposable lands of the public domain, while Section 14, Paragraph 2 covers private property or patrimonial property of the state. Remember our Article 421 of the Civil Code, di ba? Which defines patrimonial property of the state. 420 refers to property of public dominion, di ba? And then the distinction between the two provisions could be found in the inapplicability of prescription to alienable disposable lands of the public domain, which are not yet expressly declared by the state to be no longer intended for public service or for the development of national wealth. Kita natin yun sa Article 420. Now, in other words, Section 14, Paragraph 2, deals with the acquisitive prescription, no? Which is provided for under Articles 1117 to 1138 of the Civil Code, a fact that does not hold true with respect to the Paragraph 1 of the same section. No? First, in many cases, the difficulty lies in the fact that very seldom do we hear the state, no, or the government expressly declaring a public land as A and D, and at the same time, also a patrimonial property of the state, which are twin requirements that must be complied with in order to begin the period of acquisitive prescription. In other words, even if the land is already declared as alienable and disposable, it will not start, no, the period of prescription unless the government makes another declaration, express declaration, that that A and D land is no longer needed for public service or for the development of national wealth. You get it, class? Class tuloy, parang klase, no? But the second one is there are cases that are usually involving extraordinary prescription. In other words, mas madalas na ang kaso ay extraordinary prescription, no? Not the ordinary prescription. Kasi ordinary prescription will be requiring good faith and just title, no? Diba? Meron tayo sa ating property na con titulo justo y buena fe, no? With good faith and just title. Pero siyempre, wala namang gano'n. Mahirap i-prove yun. And therefore, often, most of the time, the cases involve extraordinary prescription, which will require 30 years of continuous possession. No? Ordinary prescription is seldom, if ever, attained. Okay? Now, what are the steps taken to address the issues that I have discussed? Ilang minuto na lang ba ako? Baka sumusobra ako, medyo i-alert nyo ako. In 2010, Congress enacted RA 10023. Tawag namin ito 123, 123. Kasi 100 and then 23. Para madali na matandaan. 10023 or the Residential Free Patent Law. Now, that law aims to ease the requirements and procedures of titling under the Public Land Act and other laws, and it authorizes the issuance of free patents on land sold as residential, mga residential lands. And it gives the Department of Environment and Natural Resources the authority to adjudicate untitled A&D of the public domain through the more efficient and less costly process of public land titling. Libre ito no? Kung ikaw mag-a-apply ng residential free patent, libre. Ang pati survey, sagot ng DNR. No? Okay. Next. Now, before the enactment of RA 10023, the process of titling, administrative titling of residential lots, can only be done through the direct sale. No? We mentioned po kanina yung direct sale under RA 730 through miscellaneous sales application and by way of bidding, pursuant to Chapter 4 of the Public Land Act. Now, the procedure then was very tedious and cumbersome on the part of the applicants. Siyempre, mga maliliit na mga underprivileged citizens, sila yung nag-a-apply dito. And the strict requirements with respect to the documentation. No? Medyo mahirap yung mga documentation requirements. And of course, the prohibitive costs of the land to be paid by them to the government, which are assessed and priced at their current valuation. So medyo mataas din, may gastos din. No? Okay, next. Next slide, please. Ayun, pala ko, iniwan na naman ako ng natin. Anyway, it covers residential land, of course. Sabi ko, residential land, and they must be zoned under a zoning ordinance of the municipality where the land is situated. They must be zoned as residential lands under the zoning ordinance. And there must be a showing that they are not needed for public service or public use, meaning they are already patrimonial property. And subject to the following limitation, for the highly urbanized cities, the area shall not exceed 200 square meters. For other cities other than HUCs, the area shall not exceed 500 square meters. For first and second class municipalities, the area should not exceed 750 square meters. And for third to sixth class municipalities, the area shall not exceed 1,000 square meters. Okay. Now, on July 16, 2021, that is 2 months ago, 2 months ago, Congress enacted RA 11573, which is entitled An Act Improving the Confirmation Process for Imperfect Land Titles and amending for that purpose the Public Land Act and the Property Registration Decree. Okay. Sige. Next slide. The amendment introduced by Section 2 of RA 11573 has the following effects. Number one, it reduced the number or the required period of continuous occupation and cultivation from 30 years down to 20 years. Medyo maganda ito, di ba? Kasi bumaba. Number two, it changed the reckoning period of prior occupation and cultivation from the effectivity of RA 6940, that was the last law, prior to this latest amendment, which amended the Public Land Act. And that was approved on March 28, 1990. It changed it to the actual date of the filing of the application for agricultural free patent. So maganda nabago na siya, hindi na siya nakabase sa RA 6940. Now, under Section 3 of PD, or rather RA 11573, it no longer requires the issuance of a presidential proclamation fixing the period for each local government unit within which applications for free patent may be filed. Maganda ito kasi dati kailangan pa ng presidential intervention. No? Ngayon wala na. No? Wala na. Now, the same provision provides that all applications for agriculture free patent shall be filed before the Community Environment and Natural Resources Office of the DNR. Or if there's no CENRO, the PENRO, meaning the Provincial Environment and Natural Resources Office of the DNR. Now, it mandates the CENRO or the PENRO, as the case may be, to process that application within a period of 120 days, at least 4 months, no? 4 months, including compliance with the required notices. Okay, sige, bilisan natin. At ako'y 7 minutes na lang natitira. Now, CENRO will forward the recommendation to the PENRO if the land is below 5 hectares, to the DNR Regional Director if the land is between 5 to 10 hectares, and then to the DNR Secretary if the land is between 10 to 12 hectares. And then it provides, no, upon the receipt of the recommendation by the CENRO, or upon the completion of the processing of the documents, that the PENRO, the Regional Director, or the Secretary of the Department of Environment and Natural Resources, as the case may be, is given a period of 5 days within which to approve or disapprove the application. So, mabilis, di ba? 5 days. Otherwise, ang presumption dito is, application ito, if they do not approve or disapprove, that is deemed approved, di ba? So, considered as approved. Okay. Next. Now, who may apply for free patent? He must be a Filipino citizen. He must not own more than 12 hectares of land, whether private or whatever. No? Kung ano man siya, kung nabili ba niya yan or grant sa kanya ng gobyerno. Basta he must not own more than 12 hectares of land. Must have for at least 20 years prior to the filing of the application continuously occupied and cultivated AND public lands, no, which are not covered by any existing certificates of title. Now, he must also have paid the RPT, no, the real property tax on that particular land. Okay. Next. Next slide, please. Now, as to judicial confirmation, who may apply? Of course, he must be a Filipino citizen. He must be occupying unalienable and disposable land of the public domain. His title to such land has not been perfected nor completed. And he must have been in ocean. Ano ba yung ocean? Lumangoy ba ito sa dagat? Hindi. Must be in open. Ano nga yun? Nakalimutan ko. Continuous, exclusive, and notorious possession and occupation of the land for at least 20 years, immediately preceding the filing of the application for confirmation. Okay, next. I'm doing it fast kasi I'm given 5 minutes na lang yata. No? Now, what is the distinction, the basic distinction between these laws, no? The provisions of law? The basic distinction between the judicial and administrative titling lies in the fact that in a free patent application, meaning administrative legalization, the applicant must prove actual continuous occupation and, no, may importante dito yung cultivation, no? Kasi ito yung public agricultural land, malalaki yung lote, no? As opposed to a residential free patent na maliliit lang yung lote for residential lang. This is parang ano to, farm lot, no? Farm lot. A residential combined with agricultural. And then as well, in a judicial confirmation of imperfect or incomplete title, the applicant must show ocean, no? Open, continuous, exclusive, and notorious possession and occupation of an alienable and disposable land of the public domain under a bona fide, no? Bona fide claim of ownership. Okay, next. Now, well, a mere casual cultivation of portions of the land by the claimant does not constitute possession under a claim of ownership. Well, in that sense, possession will be regarded as not exclusive or notorious, so as to give rise to a presumptive grant from the state. Alam naman natin na public lands can be acquired by way of grant or sale. Grant or sale. Now, the bona fide, meaning good faith, bona fide, in prescription, alam natin, sa prescription, di ba? Bona fide, good faith, and just title. But we are talking here of good faith. Good faith of the possessor consists in the reasonable belief that the person from whom he received the property is its owner or could transmit his ownership. No? That is provided for under Article 1127 of the Civil Code, and of course in the case of Titong versus Court of Appeals. Okay. Oh, yun pala, no? I'm already done with my second edition of Land Titles and Deeds, which I hope will be coming out in a few months, no? In a few months. And I titled it The Laws on Land Titles and Deeds, Revisited and Updated. And it will include Republic Act number 11573, which amended the Public Land Act, and Presidential Decree number 1529. Oh. Okay, sige. That will be all, no? Thank you very much for listening.
All right. So thank you very much, Attorney Claridades, for giving us that very insightful talk on land titles and deeds, or as us law students and academicians like to call it, LTD. Actually, sir, that was a very good review that you gave us a while ago, especially for those who took LTD before and those who are about to take it right now. And thank you, rin po, sir, for giving us your insights as to what may be improved on the system, what are the different doubts that we have based on the laws that we currently see right now in our LTD. And I do believe that our audience may have questions. But for now, sir, since we are in limited time, would it be all right if we would forward their questions to you directly? Since I believe, sir, you'll have a schedule after this.
Yes, sure.
Yes, sir.
And I'm sharing this presentation to everyone who would request a copy of this PowerPoint.
All right. Thank you very much for that, sir. So I bet everyone heard that well. So if ever you need the presentation or you'd want to get a copy, I believe you may already message ALSP directly through this page, or later on we'll give you their contacts for this one. So yun din po, Attorney Claridades, thank you again for giving us that very, very knowledgeable and insightful talk. And right now, I believe at this juncture, we can present our certificate of appreciation to Attorney Claridades. So the Association of Law Students of the Philippines presents the certificate of appreciation to Attorney Alvin Tala Claridades for being one of the resource speakers in the webinar event, What's New on Judiciary and Land Titles, organized by the Association of Law Students of the Philippines, Incorporated, held on September 20, 2021. So with this, I believe we can take a few seconds for a picture with Attorney Claridades. Okay, so 1, 2, 3. All right. So, okay, once again, thank you very much, sir, for gracing us in this event. And we truly appreciate all your great insight for land titles and deeds.
Yes, thank you for inviting.
All right.